Good morning, everyone. I'm John Baza.
Hold on 1 second.
He said he's not going to make
Good.
it.
Okay. Again, good morning, everyone. I'm John Baza, the Director of the Utah Division of Oil, Gas, and Mining. It's 10 a.m. on September 12th, 2017, and this is an informal hearing to receive comments on the Division's tentative approval of Geneva Rock Product Incorporated's application for an amended Notice of Intention to commence large mining operations, or NOI. Once the Division reaches a tentative decision on an application to amend an NOI, the Division gives notice to the public and provides a deadline for public comment. If the Division receives any written objections of substance during the public comment period, it must hold an informal hearing where it can accept comments from the parties and members of the public. These informal hearings are governed by Administrative Rule R647-5-106. You'll notice that I've arranged for a court reporter to transcribe this hearing. I would ask that, to allow the court reporter to properly capture the comments made today, we avoid having more than one person speak at a time, and that you properly identify yourselves when it's your turn to speak. You'll also notice that we are live streaming this, and this is going out on YouTube. So please remember that, and let's try to have appropriate decorum for this hearing today. Now I'll provide a brief background on how we got here today. On May 12, 2017, Geneva filed an application for amendment to its NOI. The Division tentatively approved the amended NOI on June 13, 2017, and Mr. Jason Rickabaugh provided a written objection to the tentative approval on July 21, 2017. After receiving Mr. Rickabaugh's comments, the Division scheduled this informal hearing to give the parties and the public an opportunity to provide comments on the tentative approval. I expect that each of the parties received the letter outlining the procedures and scope of this hearing that was sent out last week. I'd like the parties to keep that letter in mind when providing comments today. For the benefit of everyone in attendance today, I'll briefly summarize the contents of that letter, which relate to two things: the procedures that will follow today and the scope of the hearing. With respect to the procedures during the hearing, the Division, Mr. Rickabaugh, and Geneva will each have 15 minutes to comment on the Division's tentative approval. We'll start with the Division, then turn to Mr. Rickabaugh, and finally to Geneva. To ensure an efficient hearing, there will be no direct cross-examination of witnesses, and I will not permit arguments back and forth between the parties. Once each of the parties has presented its initial comments, I will then give each party 5 minutes to make any other response points or to respond to anything said during the previous comments. After the parties have presented, I will open the floor to public comment, and we'll give each commenter around 2 to 5 minutes, depending on the time available and how many commenters have signed up. If you plan on making a comment during the public comment period and have not done so, please sign up on the sheet located on the podium at the back of the room. After this informal hearing concludes, the public comment period will stay open for 10 days until September 22nd, 2017. If anyone wishes to submit a written comment in that time frame, please send it to my attention at the Division of Oil, Gas, and Mining at 1594 West North Temple, Suite 1210 in Salt Lake City, Utah, 84116. This leads me to the second point addressed in the letter, the scope of the hearing. The purpose of this hearing is to receive comments on the division's tentative approval of the amended NOI. Therefore, please limit your comments to matters relating to the amendment. This is not an opportunity to express concerns about other portions of this permit, which already exist, to discuss Geneva's neighboring Utah County permit, or to raise issues over which the division lacks jurisdiction. Any comments that do not fall within the scope of this hearing hinder the purpose of the hearing itself, and the division will not be required to consider those comments during its additional review. With that, I think it's appropriate to begin. If there are attorneys here, I would ask them to make their appearances at this time. And I think, Mr. Rickabaugh, you may want to introduce yourself by name.
Hi, I'm Jason Rickabaugh. I'm a resident of the Salt Lake Valley.
Okay.
I'm Richard Hall. I'm an attorney for Stoll Reeves and counsel for Geneva Rock Products.
And for the division?
Meg Oswald from the Assistant Attorney General's office, and I represent the Division of Oil, Gas, and Mining.
Okay. With those initial introductions, let's go ahead and turn it to the presentation. So thank you. And Ms. Oswald, you and the division can go first.
Okay. Thank you, Mr. Raza. As I said, I'm acting as counsel for the division in this matter, but due to the informal nature of the proceeding, I'm going to allow the division to do the majority of the talking. I have with me Dana Dean, Paul Baker, and Leslie Hepler. I'll call first Mr. Baker. Please state your name and your position with the division.
My name is Paul Baker, and I am manager of the Minerals Regulatory Program for the Division of Oil, Gas, and Mining.
Okay, thank you. And I think Mr. Baza covered some of this, but I'm also going to ask Paul to just provide us with a little bit of background information on the division's process.
Okay. So the notice of intention to commence large mining operations, or NOI or notice, was submitted. The original submittal was in 2005. The company, Geneva Rock Products, was originally operating as a sand and gravel mine, which was exempt from regulation by the Division of Oil, Gas, and Mining. And in about 2005, they began mining into bedrock. And at that point, the division required that they submit the notice of intention. And so we received the original notice of intention on November 15th, 2005. We went through several reviews of that notice, and the final approval letter was signed on March 30th, 2009. And as Mr. Baza discussed, some of the information in this slide was already discussed. So the division originally received this revision proposal on December 22nd, 2016, and as is customary, we went through a few rounds of review and response. So they submitted the original one in December. We responded in February. They responded back in March, and then again in May. And as Mr. Baza said, the tentative approval letter was issued on June 13th, 2017, and then it was subsequently advertised because we considered this to be a significant change to the operations. And we did receive comments from Mr. Rickabaugh. So I just wanted to point out just a little bit what some of the changes are. On the left side of this slide, you see a map from the current notice of intention. And if I can use the cursor, I guess this isn't working. The green area shows the pit floor as is currently approved. And so there would be high walls coming down from the east, basically from the east, west, or from the east, north, and south, and creating this pit floor, this flat pit floor, which could be either revegetated or it could be used for some sort of development, like a commercial development. The proposal that we have, though, is for Geneva to continue mining, and basically the pit floor would be eliminated, and so they would continue mining and create high walls all the way around. And so the pit floor, as currently approved, would be at an elevation of approximately 4,600 feet, where the bottom of the pit on the right side would be at an elevation of approximately 4,000 feet. It might be a little bit different than that, but approximately 4,000 feet, so about 600 feet lower than it currently is. The other main difference here is on the east side, there's the disturbed area boundary. If you can see, there's it does not quite match up with, I believe it's a section line. It might be a quarter section, I don't know for sure. But it extends just a little bit east of that. There's a little bit of a jog there. And in the current proposal, that would match up with the line, and so it would be straightened out, basically. So that's what the current proposal is.
Okay, thank you. And can you tell us the change on the east side, would that alone have triggered this significant revision requirement and the requirement for public comment?
No, the change on the east side is relatively minor, and it's actually contracting the disturbed area, so no, it would not have been a significant revision.
Okay, thank you. And can you also tell us what changes, if any, were made with respect to air quality or with respect to Geneva's air quality control plan?
There were no changes to the air quality plan.
Okay, thank you. Do you have anything else to add, or?
No, I don't believe so.
Okay, thank you. With that, I'm going to move to our next person from the division, Ms. Hepler. Would you please state your name and what your position is with the division for the record?
My name is Leslie Hepler, and I'm environmental scientist 3 with the division.
Okay, and can you tell us what your role with respect to this permit is, please?
My role today is as a Salt Lake County lead, which includes mine inspection, review of the NOI, and correspondence. I recently reviewed the submittals regarding the proposed change.
Okay, thank you. So the comments we received focused mainly on a few things within the division's jurisdiction, so I'll just have Ms. Hepler address each of those in turn, starting with the mitigation of effects on air quality. Go ahead.
There was no changes that were submitted to air quality. There is 2 rules that apply to air quality. The first one is R647.
Go ahead.
-4-109.4, and it reads, what are the proposed impacts of mining operations on slope stability, erosion control, air quality, and public health and safety? Geneva had addressed this on page 27 of the NOI that was approved on March 23, 2009. They provided us with the air quality order that was approved by DAQ. It was DAQ order number AN 105-65001-4-08. In addition, there is another rule that applies to air quality, and the rule is R647-4-109.5, and it reads, action which are proposed to mitigate any of the above referenced impacts. Geneva had already addressed this in their NOI that was stamped approved on March 23, 2009 on page 27, and they abided to have a fugitive dust control plan that was acceptable to DEQ. In addition, in inspections out at the site, I documented continued mitigation of air quality.
Okay, thank you. We also received some comments with respect to groundwater. So if you could please address the changes in the permit with respect to groundwater.
There are two rules that apply to groundwater. The first one is R647-4-109.1, and it's a projected impacts to surface and groundwater. Groundwater was addressed by Geneva with the submittal on May 12, 2017 regarding groundwater with figures 7 and 7A. Here's a picture of both 7 and 7A. One's the plan view and one's a cross section. Both of them indicate the same thing. They both indicate that there will be a new pit bottom that's slightly below the 4,000 foot level, and both figures indicate one-to-one slopes that are allowed per our rules as per R647-4-111.7. Because of these changes to the plan, a new depth, and Geneva needed to address the possibility of groundwater. I requested they addressed it, and they made two changes to the plan. And these are related to what are the what are they proposing to mitigate any of the references because of the increase in depth. And there was two changes that were made to the plan that were submitted on May 12th. And the first one was on page 23, and the second one was on page 26. In addition, the division verified groundwater data from the Division of Water Rights. The two changes that were made, the first one was made on page 23, and Geneva committed to dewater the excavation as it progresses down into the water table. Any water that is pumped from the dewatering process will be used for dust control or aggregate washing, and water is to remain on site. The additional change that was made to the plan was on page 26. And they added the word infiltrate to the end of the sentence that included instead water. Storm water would primarily run off and reach the pit floor areas where it would spread, pond, and evenly evaporate or infiltrate.
Okay. Thank you, Ms. Hepler. So in your opinion, does the permit and the revisions that were made address and mitigate potential impacts to air quality and to groundwater?
Yes, they do.
Okay. Thank you. Nothing further from the division at this time.
Okay. I do have a couple of questions. First of all, would you be willing to send me a copy of the presentation as well as to the parties in the hearing today?
Yes.
Okay. Secondly, my question is to Mr. Baker. I'm trying to understand a little bit. So the area that was in the initial NOI approved, I mean, there was obviously a disturbed area within the permit. How much area did that cover?
I'm not sure how many acres. Do you know, Leslie?
$335.
335 acres.
Okay. And frankly, any of the division can answer these questions, but so as I understood what you said, that the amendment was actually a contraction to the disturbed area. So what caused this to be a significant revision?
The reason it was a significant revision was because of the pit floor. Originally, it was going to be the large flat area that was shown in green on the slide. And instead of having that flat pit floor at an elevation of about 4,600 feet, they would continue mining down, and there would essentially be no pit floor. It would just continue with high walls all the way down on all sides down to the bottom to an elevation of about 4,000 feet.
Okay, so it was going to go deeper.
Yes, and that's the reason we considered it to be a significant revision.
Okay. Okay. And that's why, Ms. Hepler, you indicated that there would be some groundwater impacts that needed to be addressed, right?
That is correct. When you go deeper into the ground, you usually get water at some point.
Okay. Okay. All right. Anything further from the division at this point?
Not at this time, thank you.
Okay. Mr. Rickaball, we'll turn it over to you for a few minutes.
Thank you. The updated tentative NOI indicates the mine's depth will be below the elevation of the nearby Jordan River and Great Salt Lake. It is inevitable the holes will fill up with water. My questions are how much water will be retained by the pits? Are we going to have two ponds with depths near 1,000 feet? It is my understanding that the imperative goals of the Mine Lands Reclamation Act are to address what happens to the land when the mine has terminated operations. Title 40, Chapter 8, Parts 2, Sections 2 and 3 read, "It is necessary to alter the surface of the earth to extract minerals required by our society, but this should be done in such a way to minimize undesirable effects on the surroundings. Mine lands should be reclaimed so as to prevent conditions detrimental to the general safety and welfare of citizens of the state and to provide the subsequent use of lands affected. Reclamation requirements must be adapted to the diversity of the topographical, chemical, climatic, biologic, geologic, economic, and social conditions in the area where the mining takes place. The questions I asked the mine operator and the division are these. Do the current final depths outlined in the tentative NOI meet the legislative findings of Title 40, Chapter 8? Does digging two 1,000-foot pits in the middle of a major metropolitan area, which is undergoing exponential growth, make sense in regards to the general safety and welfare of the citizens and subsequent land use concerning the economic and social conditions? Will these deep pits and subsequent water retention pose a threat to nearby residents after the mine has terminated operation? What impact will the two potential deep ponds have on the surrounding environment? Is the land of greater economic use to the state and residents in this growing metropolitan area, which already has limited land resources? Other serious concerns for the public are as follows. The NOI fails to observe Utah DOGM Rule R647-4-104-2. It does not identify Sitla as a mineral rights holder. I believe that the rules are clear. They say the mineral rights holders and not the mineral rights that are being mined should be listed. I believe it is a well-known fact to the division and the operator that the lands affected include Sitla mineral rights lands, and that some of the minerals that have been mined belong to Sitla, and the beneficiary of the state funds the school children of Utah. This is well outlined in my public comment. The NOI also fails to observe DOGM Rule R647-4-107-6 for concurrent reclamation. The division has not recognized any reclaimed areas at the mine. The 2016 Large Mine Progress Report dated January 6, 2017 indicates in 2016 only 982 tons of material were removed. That's like 30 truckloads of material. Should the reclamation be started on the 300 acres of disturbed land if only 30 truckloads of material were removed in 2016? The mine also has erosion on steep parts of unbonded lands, which are part of previous violations. If the mine operator cannot control the erosion from the small section, how can it assure the community that the deep pits they are about to create will not have similar or even catastrophic effects on the lands after the mining operations have terminated? Please understand that these bare, unreclaimed grounds contribute to a significant amount of pollution, which affects 2/3 of Utah's 3 million residents. The mine is in a known wind corridor, which has winds exceeding limits requiring fugitive dust mitigation. According to nearby weather stations, the winds are so high, the mine is not required to use fugitive dust mitigation more than they are. Toxic dust can be seen escaping the mine and drifting into the adjacent neighborhoods and state facilities, which affects residents, state workers, and inmates in the care of the state. These high winds regularly cause fugitive dust to affect the health and quality of life throughout the Salt Lake and Utah valleys. Can the mine operator and the division assure the community that the depth of these pits match the mandate and mission of the division in its enforcement of the Utah Mine Land Reclamation Act? If the tentative NOI is approved, will it minimize undesirable effects on the surrounding area? If the tentative NOI is approved, will the post-mining land use contribute to the general safety and welfare of the citizens? Will the reclamation be adapted to the economic and social conditions in the areas at the point of the mountain? Thank you.
Okay, similarly, I have just one or two questions for you, Mr. Iqbal. The fugitive dust that you talked about in the high wind conditions
Yes.
at the point of the mountain, I'm not an expert or don't have any knowledge of what the requirements are there, but did I understand you to say that the fugitive dust control plan was somehow abrogated because of the high winds? Or?
Yes, I believe, if my memory serves me correctly, if the winds are over 20 miles per hour, no fugitive dust control measures are required. And at the point of the mountain, it's what they call a venturi. Both valleys funnel the air to that point, compress it, and accelerate it. Regularly, every morning after around 8, sometime between 8:30 and 10 o'clock, the winds often exceed 20 miles per hour. And this is in this is on the surface. This doesn't include what happens up higher with the hill compression on the sides of the hills. One thing I'd also like to add is that one thing that helps me to appreciate the power of the wind is that it is not a linear, the formula for wind force is not linear. It's a squared function, meaning that double the wind speed is 4 times the power. So at the difference between 10 and 20 miles per hour is 4 times the power of the wind at 10, and it keeps going up.
So is the concept that if the wind's too high, they don't have to control dust? Is the intent on that the dust is going to blow away, therefore they don't have to control it? I don't quite understand.
I believe it is next to impossible for them to control the dust when the winds and the force of the wind is so great, when it exceeds that 20 mile per hour wind speed. To help the division understand how powerful this is, I believe Geneva, maybe they can correct me if I'm incorrect on the numbers here, but they have like 1 million gallon per hour or something like that water jet that they're using for fugitive dust mitigation. From 110th south, when the winds are about 40 miles per hour, you can see that water jet shooting up several hundred feet over the top of the mountain. That is a lot of liquid to be putting up that high in the air.
Well, I appreciate your information. Again, this is an area that I don't really understand, and I think it's something that's addressed through the DAQ requirements, but we'll talk a little bit more about that.
Okay, my main point about that is about the need for concurrent reclamation.
Okay, thank you. Mr. Hall, you want to go ahead with your presentation?
Well, I appreciate the opportunity to be here this morning and respond to some of the comments that have come from neighboring landowners with regards to this permit amendment. Geneva Rock Products, the company, is certainly sensitive to the concerns of our neighboring landowners, and we do everything we can do to address those concerns. within reason. We recognize that we're operating a mine there, and there will be some impacts on the neighboring landowners. But we certainly are sensitive to those concerns and want to work with them in any way we can. As has been outlined by the division this morning, Geneva Rock is operating in compliance with its permits out there, including its air permits and others there. And to the extent we're here today talking about this NOI and the scope, I think we need to keep in mind, and as Mr. Baker pointed out here, we're really today here talking about the extension of the floor of the permit. That's what triggered our significant revision here, and the potential impacts of that change in the permit. I appreciate Mr. Rickenbaugh's concerns over there, but we do need to keep in mind that there hasn't really been a direct correlation between the extension of that pit floor and the DAQ or the air quality concerns that he's raised, nor has there been any evidence that we're out of compliance with the DAQ requirements we have there. So I think as we focus in on the scope of this hearing and specifically the amendment itself, we need to keep in mind that we're looking at the extension of that permit floor. He also, I think there was reference to a 1,000-foot pond there. I think as was pointed out, the division that floor won't be going that deep. But with regards to the floor itself, or to the extension of the permit floor, we've certainly operated or prepared a plan in accordance with the requirements from the division, have addressed the ongoing air quality requirements out there with regards to DAQ. I think Ms. Hepler pointed that out as well. The Geneva Rock intends to comply entirely with all of its requirements with the division, with DAQ, and any other landowners there. To address a couple other points that I'll admit are outside of the scope of this hearing, though, that have been raised by Mr. Rickenbaugh, I think we just need to address it here. One of the issues that he raised was with regards to Sitla's mineral rights out there. And it is true that a portion of the mine is the subsurface, the mineral estate is owned by Sitla. We do need to keep in mind, though, that mineral rights or that sand and gravel are not considered part of the mineral estate. So that to the extent that Sitla owns mineral rights out there, it has been determined that those mineral rights do not include the production of sand and gravel. And to date, and Sitla certainly I think would concur with this, there hasn't been identified any mineral rights out there, any types of minerals that would fall within the claim of a mineral rights owner such as Sitla. So while the comments address this issue about mineral rights out there and whether Sitla needs to be on board, the reason they're not, and they're certainly aware of this pit, I can assure you of that, and they're aware of their rights out there, but sand and gravel are not included within the scope of interest held by a mineral rights holder. That's why Sitla just hasn't been involved out here. These are not, the sand and gravel are not their interests out there, and to date no one's claimed that there's any other minerals out there, be it oil and gas, coal, gold, silver, what have you, that fall within the scope of a mineral right holder's interest. So that's why we haven't seen much discussion there with Sitla. With regards to concurrent reclamation out there, certainly we have a reclamation plan in place. Once those disturbed areas become unused, per the regulations and per the plan, concurrent reclamation would commence. But at this point, there aren't any areas within the pit that we consider, the disturbed areas within the operation, that we are considered ripe for reclamation at this time. So again, Geneva Rock is committed to operate within its permit there, but at this point none of those areas are ready for reclamation. And as I think the division is well aware, it makes little sense to commence reclamation with an area that you intend to go back into and disturb again, and that reclamation process is long, requires us to reestablish the vegetation, so we're not going to commence reclamation in an area that has the potential to be redisturbed. Again, both issues that have been raised in the objections, both issues are outside of the scope of what we're reviewing here today, but nonetheless warrant some comment, and just to address the concerns and the sensitivities of our neighboring landowner. But I think in the end, the point here is the proposal that has been made in the amended NOI is in compliance both with slope, with groundwater. We remain in compliance with air quality as well. We've done everything we can to operate within the limits of the permits out there, and do all we can to be good neighbors out there. Again, recognizing that our operations aren't always maybe the most popular thing with the neighboring landowners there, but we do everything we can to minimize the disturbance. And I think as a final point, that needs to be what's kept in mind here, that Section 40 that Mr. Reckenbaugh referred to discusses minimizing the disturbance. It's impossible for us to absolutely eliminate the impacts of these operations on neighboring landowners, nor is that the intent, and never has been the intent or the purpose of the statute. We do everything we can within the requirements to minimize those impacts and then minimize the effects on the neighboring landowners and do all that we can to help them. But at the end of the day, there are and always will be some impacts. But we limit those to within the requirements of the state and the requirements that we have to meet under the regulations. So with that, I don't think I have any further comments other than I think the permit amendment speaks for itself, and that we've done everything we can to operate or to propose a permit that's within the limits, and we appreciate the review from the division. I think oftentimes the comments that come up question the adequacy of the divisions and DAQs and others' review. And we certainly think that a thorough review has been done by qualified experts, and they've identified that the permit should be approved. So thank you.
And likewise, I have a couple of questions for you, Mr. Hall. And I know you don't have Mr. Sumption here to help answer some of these, and he may have to wait until we can hear from him. But you mentioned a couple of times that Geneva is very concerned about its neighbors and doing business in an appropriate manner. Is Geneva under any special zoning or local government conditional use requirement that goes beyond what the division manages?
My understanding is that we are zoned within the area. I believe it's Draper City there. I don't believe it's unincorporated Utah County. I'd have to confirm that, but familiar with all of our pits and all of our operations that we have up there, we regularly fall under the local land use requirements there and have to operate within those requirements. And that's just one more layer of regulation that we do. I mean, between the division and DAQ and local land use and others, we certainly have multiple layers of regulations that we have to meet, and Point of the Mountain Pit wouldn't be any different.
And you mentioned also about the SITLA mineral rights and the fact that sand and gravel are not part of the mineral estate. Who normally owns sand and gravel?
Under state law, and it depends, it's always an interesting question here, but if you're talking about private lands or within the state itself, those are generally held by the surface owner. In most, with the exception of instances where you have, well, I guess we could go on here a little bit, but sand and gravel typically are part of the surface estate as opposed to the mineral. That can be changed if a reservation that creates a severance of the mineral estate, if it contains an express reservation of sand and gravel. So if you have a general mineral reservation in it, law usually provides that is the sand and gravel remains with the surface unless there's an express reservation of sand and gravel. That's not always true on BLM lands. There are certain types of BLM reservations and original grants that the courts have determined that the federal government retains sand and gravel on a limited basis. Not always true in most reservations, but on a limited basis, sand and gravel will be deemed part of the mineral estate on the federal level. On the state side, unless there is an express reservation of sand and gravel will pass to the surface estate and be retained, and understandably so. If every mineral reservation contained sand and gravel, there would be very little for the surface owner, for the surface estate owner, because almost every property has some level of sand and gravel, and that's not the intent, that the mineral owner would take everything. So sand and gravel typically is retained with the surface owner, and that's true of SITLA.
So in the case of this mining operation, Geneva either owns outright the surface or has authorization to use that surface.
Right. My understanding is either there's not been a severance of the mineral and surface estate there, so it's all been contained in one estate, and that would be all minerals, all surface, and then sand and gravel as well. In this case, this was a portion of it as an original state section. And so SITLA owns, I think, retained the minerals on that, sold the surface of it, but does not retain an interest in the sand and gravel.
Okay, thank you very much.
Yep. Thank you.
Well, with that, we're going to give a few minutes to respond to anything that you may have heard so far today. And again, we're going to do that in 5-minute increments. So I'll turn some time over to Ms. Oswald to give the division a chance.
Okay, thank you. I'll just address also the SITLA issue. I think it's been pretty well covered, but I'll just say that I did speak with Sitla's attorneys and confirm what Mr. Hall stated. Specifically, the attorneys for Sitla sent me plat maps which show that the sections acquired by the state did not reserve sand and gravel. So I can provide those patents and plat maps if that's helpful or useful for anyone here. And then moving back to the air quality issue, I think we've covered that it's both not exactly within our specific jurisdiction and not changed in this tentative revision, but because it is such a significant part of the comments that Mr. Rickabaugh provided, I asked Ms. Hepler just to explain briefly to us what Geneva does to mitigate and what she observed on inspection.
I've got two different dates of inspection. One was on May 12th, 2013, and they started a really extensive fugitive dust program of doing pipelines and surge pumps and storage on the mountain. And this is a close-up view on that particular day where they're getting ready to pull a 10-inch feeder line up the hill. This is farther up the hill where I'm sitting on the high wall looking back. That small gray area that you see is where they were prepping the pipe. What you see in the middle of the photo is the new grade that they're cutting to pull the pipeline up. And what you see above that grade is you see the new slope that they've cut that they're covering with topsoil, which would be considered concurrent reclamation. In addition, later on in 2016, when I was out on inspection, I took this photo that documented where you can see one of the stockpiles up above with one of the cannons that is wetting down the stockpile slope. In addition, you can see a stacker that, if you notice the difference between the gray and the brown, the stacker obviously has water added to it, which, you know, at the end, which adds to dust suppression also. So as you can see, it's a really good dust suppression system that has. In addition, behind there, you can see that slope that's been revegetated. You can see the road that's going up to the top where the pipelines are. And you get up to mid-mountain, and you can see these two new 20,000-gallon surge water tanks that they're adding at the mid-mountain, and the plumbing there is adding it into one where they're at 150 horsepower booster to the system to take it to the top of the mountain. Here's a 10-inch line that takes it to the rest, to the very tip top of the mountain. So it's quite an extensive system. Below mid-mountain, there's also additional buried tanks and pumps that couldn't be photographed because they're buried.
So, Ms. Hepler, how does this compare with what you've seen other operators do to address dust mitigation?
It goes up and beyond any other operator I've seen.
And how does it compare to what's actually required of them under our rules and the DAQ rules?
Well, it would definitely be counted as mitigation. I can't say that it provides 100% mitigation, but it's a great deal of mitigation, that more than I've seen elsewhere.
Okay, thank you. The only other point that I wanted to address with respect to Mr. Rickabaugh's comments is has to do with the pit filling up with water. So as Ms. Hepler stated, Geneva provided their plans to pump the water out. Mr. Rickabaugh also referenced the level of the Jordan River being below, or being above, excuse me, what the level of this pit will be. So Ms. Hepler, can you just, in as simple terms as possible, tell us why the fact that it's that the pit is lower does not mean that the Jordan River will necessarily flow into the pit?
I used a third-party data, which was a division of water rights, and I went out to their site and found a well. It's shown adjacent to the highway up there in kind of a brighter red colored, and looked at that well log. That well, TD's at 1530, which is considerable distance. That's considered quite a deep well. All the rest of the wells in there are shallow. And the well log says from 0 to 2 feet is in pea gravel, from 2 to 1530 is in bedrock. And so what this meant to me, because the Jordan River is down in alluvium, and this is in bedrock. And so there's a difference between being in rock and being in alluvium.
Okay, thank you. With that, I think that's all we had, unless you have any further questions for the division.
I do. In the issue of concurrent reclamation, when do we apply those conditions? Or do we control that, or is that left up to the operator?
That can't be controlled until you're no longer using the area. So it depends on the shape of what you're mining and where you're going to go. You obviously don't want to reclaim a pit floor when you're at the 4,600 level if you're going down, because it would be a waste of money to do it twice. You do it after you're done with your mining.
But all of that reclamation is under bond. There's a financial assurance that's provided for that.
That is correct.
If I could speak, that's actually in many ways a difficult rule. The rule says that the land would be reclaimed when the mine operator, when the land is no longer needed for mining operations, and it's hard for the division to make that call. It's really pretty much up to the operator. It's hard for us to say you're done with this area and you have to reclaim it now. The operator could easily come back to us and say, no, we're planning to go back into that area in a few years.
Okay.
Yeah, Dana Dean, Associate Director with the division, if I may, Mr. Baza. I think something that may simplify it for you is you think of a coal mine where they do concurrent reclamation. They're going after one seam. Once they grab that seam, they can reclaim that and move to the next portion of that seam. Many times in other minerals, you're going downward, not along like a layer cake. And so they may need the same areas, or they may need to even go out further in order to go down further. And so you would have the same areas open for a lot longer time, just like Kennecott is much different layout than what you'd see it like in Alton coal. And so that would be the big difference between the two programs, and how easy. In coal, it's very easy to do concurrent reclamation with the surface mine. In minerals, the nature of the deposit is different, and so it's mined differently. Maybe
this is just a casual observation, but it strikes me that sand and gravel is not so well defined in terms of where you're going to find it.
Exactly.
Okay.
It could be throughout the area that you're working in.
And just one final maybe set of questions, and that's around the idea of fugitive dust control. Leslie, when you've been out there doing your inspections, has it been during any of these high wind activities that Mr. Rickabaugh was mentioning?
Yes, most days there is high wind through that area because of the Venturi effect.
Okay. And have you seen that fugitive dust is not being controlled during those times? Or?
They have done everything that's physically possible to control the dust out there.
And when you talk about Geneva going above and beyond what other operators do, are you making that comparison to other sand and gravel operations, or your entire experience as an OGM scientist?
It's definitely up and beyond for any other quarry operation that we see. Kennecott does, of course, have an extensive mitigation program too that they do. They have a system that's automated with their sprinklers. And I believe they run this 24/7, but that's probably justified by the winds that are always out there.
Thank you very much. Mr. Rickabaugh, you got 5 minutes.
Yes, I just want to touch lightly on the Sitla mineral rights. I think we could clear it up pretty quickly if we just ask the operator if they have in fact mined minerals that are considered valuable minerals and not part of the surface estates. I'd also like to point out in the operating plan, it does not state that they are mining sand and gravel, but that they are mining hard rock. And perhaps they should change that to say that they have mined sand and gravel recently. My main point in that was just to make sure that they were in compliance with the rules. So I hope we don't waste too much time on that. I just wish that they would recognize that SITLA is a mineral rights holder of the affected lands. As far as just a comment really quickly on Ms. Hepler's comments, she says that those are high winds, but I guarantee you that when she's out there, they are not high winds. Nobody wants to be out there and when the winds are like like above 25 miles per hour, closer to 40 or 50, which happens on a regular basis. And the sheer amount of energy, like I said, double the wind speeds, 4 times the power of the wind power. So it gets really rough out there, and especially when we have storms or things like that, it just completely fills the sky with dirt. Fugitive dust can be seen every day leaving the facility in great volumes. Also, to address reclamation, perhaps the division could discuss a little bit on what types of reclamation are required for high walls, and also address the fact that almost the entire pit, once they do their little Kennecott thing and spiral down to the earth, how much of the pit is actually going to be high walls, and how will that affect the reclamation? I believe it's my understanding that almost no reclamation will need to be done if the entire pit consists of high walls. Also, it is very important to address the economics mandates of the land use. This is in one of the fastest growing areas in the nation, I believe, as far as the economic development. There's going to be a development across the freeway where they're moving the state prison. Do we really want to have useless land? The current NOI seems to have the ability to use that land for the benefit, financial benefit of the mine operator as well as the community. Once again, I wanted to point out they removed about 30 truckloads and have 300 bare acres of land. I don't know where the concurrent reclamation lies there, but they have a tremendous amount of exposed land where solar radiation and winds are affecting and causing fugitive dust and moving it to very highly densely populated areas of the state of Utah. And I just want to remind everybody, Utah has grown significantly recently and has over 3 million residents in the state of Utah now, and 2/3 of those residents are affected by this mine, and I would say more so than Kennecott, because it is in the direct path right between the Salt Lake and Utah valleys. And so I'm just very concerned about the concurrent reclamation, and that the fact if they're only going to be pulling 30 truckloads of material a year out, that they do something to address that. And I appreciate Ms. Hepler's words on Geneva's doing all that they can, but the sheer amount of barren land and the energy in the wind is just so significant that Geneva cannot stop the fugitive dust. It is impossible for them. They'd have to be watering their entire property, 300 acres, and I don't think they have that much water there to be watering 300 acres on a daily basis. So I implore the division to talk a little bit about the requirements of reclamation of high walls and what percentage of the high walls of the mine will be high walls and how that affects reclamation, as well as perhaps the operator can discuss the use of the land on the west side of the freeway, which is even closer to residents and has a significant effect.
So, Mr. Rickabaugh, I do want to ask you something. It seems like some of your comments are related to whether the mine should be there at all. I understand the social and economic impacts of having that in a metropolitan development area, but fact of the matter is they do already have a mine permit. So are you suggesting that the division not just deny this amendment, but deny the whole ability for Geneva to mine?
I understand Geneva has significant financial investment, and I hope that they realize the financial possibilities over there. But I also hope that they do it very quickly to protect the health and happiness of the residents. And it doesn't seem that moving 30 truckloads a year, 960 tons according to the 2016 report, is efficiently using 300 acres of barren land.
Okay. Well, thank you. Thank you. Mr. Hall, I know that your guest has just shown up, so I might grant you a little leeway if you wanted to include Mr. Sumption in some of your response remarks.
Okay, yeah, he'll correct me if I say anything wrong here, I think. But just to go ahead, and again, we appreciate the opportunity to be here today. Just want to briefly address a couple issues that have been raised by Mr. Rickenbaugh. First of all, with regards to SITLA, he asked that we recognize that SITLA is the mineral right holders there. That's not new information to us, and we've long recognized that fact, and we'll do so here again today, that they're the mineral rights holder within a portion of that pit. That's not in a dispute here, certainly not in question. Again, I would go that oftentimes comments like this address or try to question the adequacy of the review by the division and other agencies here. We appreciate the efforts that have put in there. We think that it has been adequately reviewed and even gone above and beyond what needed to be done here. We're meeting with the compliance with the permit there. We think that and as I think as Ms. Hepler addressed out, Geneva Rock is doing all that they can to control the dust there, and we think we've been fairly successful at it. We do need to clarify one thing. It's been mentioned several times that we only ran about 20 trucks out of that pit in the last year. In fact, we run about 200 to 300 truckloads a day of material out of the pit. We wouldn't make much money on 20 truckloads a year out of there. So it is certainly the removal is at a much higher rate than has been previously stated. There's also been a question about whether or not we should shut down as quickly as possible. I think it'd be worth noting that that there's a lot of reserves within that permit right now. We anticipate a life of mine at 50 years or beyond. So we've got a significant investment there. We've got a significant commitment to that pit as well as the neighbors there. We intend to be there for a while and continue to operate in compliance with our as required by the state and do everything we can to minimize the impact. But it's a significant investment to the company, and we intend to continue to operate it for quite some time, but in compliance with what's required of us there. There's been some question as to the economics of that pit for a post-mining use. Again, outside of the scope of it here today, and certainly Geneva Rock Products, if they viewed the economics to be higher than what the current operation, they'd consider changing the land use. But at this point, it's just not it's not even for consideration here, nor is it. While there may be speculation as to it, there's certainly no evidence to suggest there's other economic considerations that should be made there. But again, outside of it there. And then I actually appreciate Ms. Hepler's slides, because I mentioned that there wasn't concurrent reclamation going on there. Indeed, there is. And I think we need to note there, while we have high walls out there, those are not shear walls. Those are one-to-one slope on those walls. There will be reclamation, reseeding that will be required to establish when those to the extent they can. And so a lot of discussion here about concurrent reclamation going on there. The time will come, and as you've seen in the photos, there has been already some reclamation that's commenced up there. The time will come that it'll all be reclaimed, but at this point, the areas that we will continue to operate in or continue to have a need for the operations, that reclamation won't commence until we're finished up with them there. Other than that, I don't know that there's any other comments we need to add. Again, we appreciate this opportunity to come out today and address the concerns of the community. Appreciate the division's review of this permit. So thank you.
Thank you. Mr. Rickenbaugh has brought up the concept of the SITLA mineral ownership and what they could control or manage. For my own curiosity, could you tell me what are the main products being mined from this operation?
I'll address that.
Pardon? Sorry. I was hogging.
Okay. The products that we make there are basic construction products, namely concrete aggregates, asphalt aggregates. Road base is a huge part of our sales. We make structural fill. So virtually everything that we produce there does not rely upon any intrinsic minerals that might be present in the aggregate. With regards to Sitla, we've met with Sitla. Mr. Tom Faddis asked, what our position was in regarding mineral rights, and we said we're using surface rights. We're using the sand and gravel for construction products. Therefore, it does not qualify as a mineral according to their classification. And he said, I thought you'd say that, and that was the end of it.
So I would assume, because you're producing materials used in construction, that the demand for those products has just steadily increased as population has grown.
That is correct. We are currently producing and selling. Going out the door is approximately 4 million tons of construction aggregates per year. And that does increase over time. I mean, it fluctuates. It dipped down after 2007, but it's risen back up in the last couple of years, 2 or 3 years. Residential construction has been very high, and the demand for product. This is a very important resource for the state of Utah. Aggregates from this pit go as far southeast as Price, Utah. The quality of the aggregate is such that it makes excellent concrete and asphalt, and for that reason we ship it to Park City, to Tooele, to Price, Utah, Fillmore. All of the outlying communities are, as well as the Salt Lake and Utah valleys especially, are benefited by these products. And I would venture to say that Mr. Rickabaugh, as well as pretty much all the others in Salt Lake and Utah County, use our products on a daily basis.
So you weren't here earlier. Mr. Hall mentioned that Geneva, excuse me, Geneva does its best to try to be a good neighbor to the surrounding landowners and things like that. Do you have any specific examples of that, where Geneva has kind of gone out of its way to be good neighbors?
Well, our motto is building a better community, and very recently we make numerous charitable donations to the community. Obviously, each one of the Wasatch Front communities use our products in a variety of ways. They're maintenance crews that repair roads, repair sidewalks and curb and gutters. They buy our products to be able to maintain their infrastructure. As far as charitable donations, we make numerous substantial charitable donations to such entities as Utah Valley University. We make very significant donations there. We've recently donated $2 million to a recreational facility in Springville, Utah. We really are interested in the environment and preserving and protecting the environment to the very best we can, and we also give back to the community in a variety of ways.
I don't think I have any more questions. This would normally be the time that we would open it up for public comment, but I'm seeing in the audience only division representatives. Natasha, could you see if anyone has signed up on the commenters list back there? No. So I would like a few minutes to discuss with council our next steps. So if you could just give me 5 minutes or so to do that, then I'll be back here and we'll continue.
If you don't have it, those are the three possible outcomes that we said, if you want to read it.
Okay. All right, we're going back on the record right now. First of all, I guess I'm going to get on a little bit of a soapbox and talk about the three objectives that the division has. One is that we are here to foster responsible development of the mineral resources of Utah. That's clear in our governing statutes that the legislature has told us that the minerals of the state of Utah are to be used and developed for the benefit of the citizens, and we want to make sure that's done responsibly. A second objective we have is to do that with a proper consideration towards protecting the health and safety of the public. Then thirdly, we do the best we can to preserve the environment. So as the impacts of mining occur, which we know they're going to occur, we do our best to try to ensure that those are properly reclaimed. I think Mr. Rickabaw's comments today have brought up items on all three of those objectives. And when I did send my letter out last week, I indicated that there's three possible outcomes of this. One is that I could affirm the tentative approval of the amended NOI, and again, it's towards the amendment, not towards the initial NOI and the permit that the operator currently operates under. The second alternative is I could remand this to the division to approve the amended NOI with conditions. Third, I could remand it to the division as a denial of the amended NOI. And then it would require a restart, basically, to say that a new application would have to be filed if the operator intends on going ahead. I think because there are some questions that have been raised today, and I think enough questions have come from me, as you've seen, I'd like to at least leave the comment period open for an additional period of time so that perhaps the division could reach out to Air Quality and ensure that we have their comment and their input in regards to the division's approval of the amended NOI. Also, there may be some people who will watch the video today that's being recorded and want to submit comments. So the result of today's hearing is I'm going to leave the comment period open for another 10 days through September 22nd, which I believe is a Friday.
It is.
And that'll allow us a period of time to get any more comments, including comments from Air Quality, as needed, regarding their view of the compliance of the operator. After that, I think the rules say that I have a reasonable length of time in which to issue a decision, which I would intend to do along the three possible outcomes that I've already identified. I think my role here as a hearing officer was not necessarily to reanalyze what the division has done. We have competent professionals within the division who do a good job of addressing these issues of NOIs and mine permits and activity going on throughout the state. So it's not my role to try to second guess any of that. But it is my role to either affirm the division's tentative approval or to strike it down or to amend it. So that's the ultimate decision that I hope to reach. I would mention that even after that's done, there is an opportunity, and this will be included in my final decision, there is an opportunity to appeal any decision made by the division to our Board of Oil, Gas, and Mining. So any party has the ability to do that. And I would suggest that if after the final decision comes out that a party is aggrieved by that decision, that's the next step, is to formally get on the board's docket and to appeal this to the Board of Oil, Gas, and Mining. So with that, and seeing that there's no other public comment today, I'm going to call an end to this informal conference, but leave the comment period open for another 10 days and see what kind of information we get in that period of time. I thank everybody's attendance today and the time that you took in making valuable presentations. And again, I would ask the division to share your presentation material with the parties and especially to me so that I can go back and review it as I need to. So thank you very much, and we'll close the informal conference for today. Thank you.